Court is reconvened. Our third case this morning is a motion for discretionary review, case number 60689-5, Robert Stordeur v. Mark Zawistoski.
And good morning, everyone. We're here on a motion for discretionary review, as we said. We're conducting this hearing on Zoom, and also it'll be broadcast on TVW. Because it's on Zoom, sometimes the angles look a little bit funny, and it may look like I'm looking left or right and ignoring the parties. I'm actually just looking at documents on another screen related to the case. So with that said, counsel for petitioner, it looks like you've reserved 2 minutes for rebuttal. You can proceed when you're ready.
Thank you, Your Honor. For the record, I'm Ken Masters representing the petitioners. We have briefed the two certifications, the 54B certification, which we believe is correct and accurate. It meets the standards of the rules, and the 2.3B4 certification, which we also believe is correct and meets the standards of the rules. So we believe, as we brief, that the court should accept review as a matter of right under this 54B certification, or take the certified issues under B4. We've also briefed B2 because the judge, in saying there is no authority, this is at 717, legal or grammatical, to conclude that the word visitor is a broad term that is narrowed by the other words around it. That is contrary to black letter law and a great deal of it. And so that's at least a probable error, and that alters the status quo for over 50 years. There's never been commercial uses allowed, commercial visitors allowed to use our private property easement. So with that, Your Honor, I'm happy to answer any questions you have, but I think we've adequately briefed the questions.
Well, I'm just confused a little bit as to how we got here. So we're here on a notice of discretionary review, and I thought that the issue seeking, I guess that's my question, is what is the notice of discretionary review seeking review of?
Well, it would be the trial court's order, right, that contains, except, as I say, 717, that language. That's what we've sought discretionary review of. And the court has certified that under B4 as a final order. So the court can take that, treat our notice of discretionary review as a notice of appeal and take it as a matter of right.
And that's where the confusion's coming in, I think, is typically when you get a 54B ruling, you just file a notice of appeal. And sometimes the clerk might look at it and say, oh, wait, this is an issue involving multiple parties or multiple judgments, and say we may have to have a hearing on appealability on that issue. But typically 54B kind of settles it. It's not final, but it kind of settles it. And here there was no challenge to the 54B ruling. It seems like you're almost teeing it up yourself.
I would not agree. I think our friends on the other side have said that the 54B finding is wrong. Findings are unsupported or incorrect. And as I understand the law, and if I'm mistaken, I certainly apologize, but it is up to you whether those 54B findings are adequate or not. So that's how we've teed it up. To the extent that we did a notice of discretionary review, that was a belt and suspenders approach, Your Honor. And of course, the rules are that you will treat it as what it is. If you agree that the 54B findings are adequate and that you should take this as a matter of right, you may do so.
Well, I get it, but I guess we're just confused here, because usually 54B ruling, we treat it as a notice of appeal. And then if the other side has a problem with it, they'll file a motion challenging appealability, saying, hold on a minute, 54B, it wasn't appropriate here. You need to take another look at it. And it doesn't really come up in the, and usually this doesn't come up on our motion for discretionary review docket. It usually comes up on our appealability docket. And it certainly usually doesn't come up by the party who got the 54B ruling in the first place.
Well, I have seen this before, Your Honor, for whatever that's worth. In my long time practicing, I've seen this, but I certainly understand what you're saying. Having not received the letter saying this is a question of appealability, I proceeded with the discretionary review. And again, it's belt and suspenders, Your Honor. I mean, he did also give us the certification under B4, so we did need to pursue that. We only had a certain amount of time to do that. We did need to pursue the B2. So we're just belt and suspenders, Your Honor. It's if the court believes that the 54B findings are adequate, that's how you should resolve the case is our position. Just accept as a matter of right the order.
All right. Thank you, counsel. I didn't have any further questions for you unless you wanted
Thank you.
to. Okay, thank you. And counsel for respondent, you can proceed when you're ready.
Thank you, Your Honor. Randall Olson of Karen Cross and Hempelman on behalf of Mark Zawistoski, Janice Wilson, and Menazai LLC. And to be clear, we do challenge the court's 54B ruling as well as the others as we've done in our briefing. So I'll summarize quickly those arguments. I mean, primarily the 54B certification, the reason there that we challenge it, and it is, of course, up to the Court of Appeals to decide whether or not that is it meets the requirements for certification, and the court accepts review. So there's a chance to take a look at that and say, is this something that the Court of Appeals should accept under the circumstances? And there are three reasons not to accept it in this case, and we ask the court to deny the motion for discretionary review on all bases. But there are three reasons with respect to the 54B, which is, one, the plaintiffs in this case have stated several times that they plan to argue that these easements, which are the subject of the order on appeal, whether or not the Court of Appeals overturns the trial court's ruling and rules in their favor, upholds our ruling, they will go back to the trial court and argue that the easements are overburdened anyway. And our position is that that's something that should be resolved in the trial court before we go up on an appeal to the Court of Appeals. Otherwise, we're just bifurcating those issues needlessly and creating more litigation, which is something that my client certainly would prefer not to do. There are also, the second reason is there are no efficiencies gained by doing this. Like I just said, we're in the trial court. Now we're in the Court of Appeals. We're going to be back in the trial court and then potentially back in the Court of Appeals again. And then lastly, there's not really a hardship at play here that gives a reason to depart from the normal appeal process. The hardship that's been identified is that these easements, which the trial court says my clients can use for access for themselves and their guests, will result in 6 additional vehicle trips per day on this road. That's not the kind of hardship that supports a ruling that departs from the normal appeal process. Certainly when it creates a corollary burden to my clients to have to continue to litigate in multiple forums. With respect to the rule of appellate procedure 2.3b4, that may be accepted when all of the following are present. The order includes the controlling question of law. There's substantial grounds for a difference of opinion. And the immediate review will advance ultimate termination of the litigation. Well,
so it seems like from the record, there was discussion about whether or not there would be an upcoming trial date, and the determination was that there is no set trial date and no reasonable possibility of a trial date in the immediate or near future. So given that discussion, I'm not sure why it wouldn't make sense to proceed without getting into the easements issue yet, when there's an indeterminate trial date.
Yeah, and we would like to be focused on the Superior Court action. Unfortunately, we've been dealing with other litigation related to this matter. We just had a ruling in the trial court on a matter, and this is in our brief in this matter, that the Stordeur's daughter advocated for a neighbor to file an appeal that the trial court recently dismissed as meritless and gave attorney's fees to my client. But that was resolved on as of Monday this week. So we've been pulled in many directions, which is one thing that we don't want to do. We would like to focus on the trial court action so that we can move that forward, set a trial date, get it resolved, and bring these issues together so that we can do this in an efficient manner.
But as of now, there's no trial date.
There's no trial date as of right now, no, for the reasons that I mentioned. Yeah. We had a ruling. This appeal was filed. The other litigation was filed, and it's taken, 4 or 5 months now to get dismissed. So we're just now free of that as of Monday. RAP 2.3b2 is the final grounds, and that authorizes review when the trial court has committed probable error. So that's the first step. And if there is probable error, then the decision also has to either substantially alter the status quo or substantially limit the freedom of a party to act. So in this case, there is no probable error. The trial court recognized that the term license in the context of real property means permission to use the land of another for a particular purpose. That it accords with the dictionary definition and the case law. The plaintiffs, and Mr. Masters mentioned this in his opening, refer to the court's statements on the term visitor and the fact that it should be given meaning rather than be rendered superfluous, and highlights that as an error under the canons of statutory construction, I suppose. Well, there are also standards of construction that say you shouldn't render words superfluous, and that all words should be given their ordinary meaning, which is exactly what the court is doing. So, and finally, on that point, the definition of visitor is really not impactful to the ultimate order in the case. The definition of licensee is what is the controlling factor there. So any error with respect to interpretation of the word visitor, which again, I don't think was an error at all, wouldn't have any effect on the outcome. Finally, with respect to so if there's no probable error, there's no reason to go to the next, the altering of the status quo or limiting the freedom to act. But to touch on those points, there hasn't been a change in the status quo in this case. Our clients got a permit to open their 7-tent site campground, and then they were able to do that. The plaintiffs appealed that. So that was the basis of their appeal, was the status quo. And ultimately the court upheld their ability to do that. So the status quo has not changed. The fact that the court issued a memorandum opinion and that he later corrected and ruled differently, I don't think was a change in the status quo. It was a correcting of an error. And then finally, no substantial limit to freedom. I guess the only freedom to act that we would be talking about that the plaintiffs could complain of is their inability to shut down access to my clients and their guests of their campground, which is a central issue in the case. And again, if we're talking about 6 vehicle trips per day, that's not really the kind of hardship that would justify departing from the normal processes for appeals. So if Your Honor has any questions, I'm happy to answer them. Otherwise, that's my conclusion. We ask that you deny the motion for discretionary review.
All right. Thank you, counsel. And counsel for petitioner, you've got some time remaining if you had anything in rebuttal.
Yes, I'll just respond to the 3 points that he made. As far as further litigation, as the trial court said, would be moot if we're correct. And so that's why the judge says there's no just reason for delay. There's no need for an overburdening argument if they can't overburden the easement. So that's why the judge said, let's get this purely legal issue resolved. Then there may not be a trial. Can't say that for sure. I mean, anything can happen in the future, but as of right now, there's no need for further proceedings if we're correct. On hardship, the court made a express finding that this is a substantial hardship to us. It certainly changes the way the easement has been used for the entire time we've owned the property. Finally, on the judge ruled on the word visitor. He did not rule on the basis of the word licensee. He couldn't have ruled that licensee is an incredibly broad term because it means someone who is on the property at the sufferance of the owner. but not for the owner's business purpose. So what the judge did in saying that a visitor is this broad term that isn't limited by the words around it, as black letter law says it is he made the easement say the opposite of what it says. That is, if you limit it to licensees, that excludes people who are on the property for the business purposes of the owner, that is, business visitors. So the word visitors just means people who come and go from a place. It's not really a legal term, but if you look in blacks, you'll find it just says people who go from a. So he has read an easement that limits to tenants, servants, and licensees. He has wiped out those limitations and said visitors means everybody, anybody the owners want to come on their property for business purposes or anything else. So it's the opposite of what the grantor intended. Certainly the grantor and their attorney would know what these words meant in 1972. The black letter law, which we cited in the trial court at that time, clearly would have said you limit a broad term in a list by the words that it's with. So the trial court committed probable error. And this does change the status quo, because the status quo for 50 years is no commercial visitors. So, and it certainly limits our freedom to act very substantially, because of course, we would not license this use. We would not have people on this very quiet back road over our property coming back and forth, back and forth, back and forth for 7 months out of the year. This is 14 people that can stay at this campsite. So 6 was an estimate, but obviously it could be much more. And that's why the judge said this is a substantial burden on us. He also said it could subject us to potential liability to those people. So we have a right to have a solid legal determination, one that, the judges ruled both ways on this, and obviously he is asking the court to take a look at it by certifying it under both 54B and 2.3 B4. So we ask the court to grant review, primarily to just accept review as a matter of right, but if not, to take it under the certification or under B2. Thank you.
All right, thank you, counsel. The matter will be taken under advisement and this court will issue a ruling shortly.
Thank you.
Have a great day.
Thank you.